Hey everyone, I'm Carolyn. Welcome back to another episode of As I See It. Well, I learned something today, and I wanted to share with you what that is. It's regarding the Second Amendment. I made a video yesterday talking about the first four words of the Second Amendment saying, what is it? A well-regulated militia. What I did not know, that I have learned since then, is that there was a Supreme Court case in 2008, the District of Columbia versus Heller. I'll put a link in the video description so you can read it all. But in the District of Columbia versus Heller, the Supreme Court on June 26, 2008 held in a 5-4 decision that the Second Amendment guarantees an individual right to possess firearms independent of service in a militia, and to use firearms for traditionally lawful purposes, including self-defense within the home. So, like Roe v. Wade in 1970, the Supreme Court made a decision that affects how we interpret individual rights, and in this case, how we interpret the Second Amendment. I think it's really interesting to read the whole argument for this ruling. So, in a 5-4 ruling issued in June 26, the Supreme Court affirmed a lower appellate court's ruling that endorsed the so-called individual right theory of the Second Amendment's meaning and rejected a rival interpretation, the collective right theory, according to which the amendment protects a collective right of states to maintain militias or an individual right to keep and bear arms in connection with service in a militia. Writing for the majority, SCALIA argued that the operative clause of the amendment, the right of the people to keep and bear arms shall not be infringed, codifies the individual right derived from English common law and codified in the English Bill of Rights 1689. That seems like a stretch to me. Why are they going to English law and English Bill of Rights when we have a constitution and it's written right there? I don't understand that. Didn't they also go back to the English law in this recent leak of the, Justice Roberts quoted English law for overturning Roe v. Wade. So this seems like a stretch to me. I mean, I guess that kind of makes sense because a lot of our Constitution might have been based on that law, but it still feels like a stretch to me, and I'm going to make a point here in a minute. The majority held that the Second Amendment's preamble, a well-regulated militia being necessary to the security of a free state, is consistent with this interpretation when understood in light of the framers' belief that the most effective way to destroy a citizen's militia was to disarm the citizens. The majority also found that United States versus Miller, another case, supported an individual right rather than a collective right view, contrary to the dominant 20th century interpretation of that decision. So we now have, we have the Second Amendment, which I read yesterday and focused on those four words. We now have, fairly recently, 2008 Supreme Court decision and precedent, I think before that, that says, okay, no, this isn't how we interpret the Second Amendment. We interpret it differently. We interpret the Second Amendment to mean that you can bear arms for individual protection, safety purposes. Here's the point I want to make. Supreme Courts have gotten it wrong in the past. Prohibition is a good example. That was overturned. And now, to use their own logic against them, the current Supreme Court is saying that Roe v. Wade got it wrong. They got it wrong in 1970. It should have never been passed. There never should have been a Roe v. Wade. And the right wing, Republicans, Christians, so-called pro-life people, have spent 5 decades fighting Roe v. Wade. They have been consistent, they have been passionate, they have been persistent in fighting Roe v. Wade to get us to the point where we are today, where we're about to see Roe v. Wade being overturned. We need to have that same passion in making sure this Supreme Court decision is overturned. I don't agree. I mean, I haven't read the Federalist Papers, and I haven't read all the other behind the scenes papers that exist for the Constitutional Convention, but I feel like this is a stretch, just like I feel like Roberts' decision to overturn Roe v. Wade, going back to the English Bill of Rights in 1689, it feels like a stretch to me, and I think that we need to be as persistent and diligent about fighting this decision as the right wing has been about fighting the Roe v. Wade. And now Roberts is saying Roe v. Wade should have never been passed. Prohibition, like I said, was overturned, and they said it never should have been passed. That doesn't mean just because now the Supreme Court has ruled a certain translation, interpretation of the Second Amendment, that doesn't mean it has to stay that way. So I stand corrected. Yes, we have a Second Amendment that reads a regulated militia, and I can't believe the Supreme Court just threw out that whole well-regulated militia part and said, no, you know what? The Founding Fathers actually meant that individuals should be able to own guns. I think that's a stretch. And I think that we need to write to our elected officials. We need to call our elected officials. Here's another thing I want to talk about a little bit off this topic. And I've been wondering lately, if you know anyone who is not registered to vote, anyone, you need to do whatever is in your power to convince them to vote. We need Americans to be involved. You know that. Everybody here knows that. We need to ask people, are you registered to vote? It doesn't matter. I don't care if you're like standing in line at the grocery store and you strike up a conversation about gum. Say, hey, by the way, do you vote? I'm not asking who you vote for. I just want to make sure you vote. It's that serious. We need to take responsibility for our country and for our own well-being and safety. So I just wanted to share that with you because I didn't know that when I made the video yesterday. And some of this stuff I learn. I love this channel because it gives me the opportunity to learn and grow and research, and I just thought I would share that with you. I still believe well-regulated militia is what the Founding Fathers intended, but I'm not a Supreme Court justice. But keep fighting the good fight. Keep fighting the good fight. All right. So that's how I see it today. Thank you for being here. I'll see you soon. Bye.